Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. In the high-profile case of Gonzalez et al. Versus Washington State University, which has been proceeding in federal court since January 27th, 2026, when the defense removed the case, it has been presiding before Judge Kimberly K. Evanson ever since. There are two pending motions that require an order from the court. On one that has been fully briefed, the other will require a future order after it is fully briefed. The motion that has been fully briefed is the defense's motion for change of venue, which they filed back on the 30th of January 2026. It is docket item number 8 with a declaration from a representative of Washington State University, Cheryl Camerzeel, document number 9, in support of that motion for change of venue. You can read those documents to determine the reasons why the defense is seeking to have venue changed from the Western District and the courthouse in Seattle, where it has been pending, to the Eastern District and a courthouse closer to Pullman, Washington. The plaintiffs came back with a very strenuous opposition to moving the case. They want it to remain exactly where it is. The defense filed a replying to that response in opposition, and that occurred back on the 27th of February. At that point, all of the briefings relative to this motion were in, and now the matter is awaiting a ruling from the trial court, Judge Evanson, to determine if this case will move to the Eastern District or will stay where it is in the Western District. And one point that I would like to bring to your attention at this time: if the case does stay in the Washington Western District where it is, there's a possibility that some of the proceedings may be live streamed because the Washington Western District Court is participating in a federal court pilot program that allows a member of the public, one of the parties, to file a paper in court asking for a specific hearing, possibly even trial, to be live streamed. That situation is not the case in the Eastern District because the Eastern District does not participate in this pilot program. The second matter that has not yet been fully briefed is the issue of the motion that was filed by the plaintiffs seeking to strike the defendant's answer. This is their pleading in defense of the case, and where they have brought forward affirmative defenses, raising issues that there are other parties, for example, or entities that may be responsible to the plaintiffs, not Washington State University, for any damages that the plaintiffs allege that they have suffered resulting from the allegations contained in their pleading, which is the plaintiff's complaint. The motion to strike the defendant's answer is document number 19. It was filed on the 27th of February 2026. Oral argument, meaning a hearing, has been requested by the plaintiff on this. They had also requested a hearing on the motion for change of venue, but as of this morning, there is no hearing set on the court's calendar. There is no response as of yet from the defense to this motion to strike the defendant's answer. We will continue to keep you posted as further developments arise. Until next time, this is Kathy. Thank you very much for joining us here today.